May I pray for listing of a motion matter tomorrow, Your Lord? The matter relates to a NSA detainee, Your Lordship. NSA detainee, Your Lordship. He was not allowed to, Your Lordship. Even advocates are not allowed to meet him in the jail, Your Lordship. That is why we have to come before this honorable court.
Preventive detention matter is otherwise division bench.
NSA matter otherwise, Your Lordship, we come before division bench, Your Lordship. But this is not, we have not challenged the detention order, Your Lordship.
Okay.
It is for allowing the advocates and other family members to meet the detainee. Your Lordship. Obliged.
Your Lordship, so I'm praying for listing of this matter, my lord, for withdrawal. Maybe on Monday, my lord. Please.
May I plead your lordship, with the consent of the petitioner, I beg to mention item number 9, lordship.
9.
9, lordship. In this matter, lordship, we are appearing for respondent number 1 to 3. This matter is led by my senior Sri Karen Chaudhary. He has some difficulty today, lordship.
Okay. Which for the petitioner? You have informed
Yes, lordship.
Ms. R.
Kakoti.
Gauhati, Learned Counsel. Being for the respondent number 1, 2, and 3, has submitted that Mr. Karen Chaudhary, Learned Senior Counsel, who is leading her in this case, has some personal difficulty today. First up, which it is submitted that if a request is made, thus made for deferment of the case on that ground. It is further submitted that consent has been taken from the Learned Counsel for the petitioner to make the request. In view of the above.
Your Lordship, I'm appearing for respondent number 4.
Okay. Miss
N. Rahman.
N.
Rahman.
Rahman, Learned Counsel for the respondent number 4 is present. In view of the above, request the list the case. The request is accepted. List the case. Okay. After on redo. Next month. Next.
May I please, Your Lordship? Lordship, with the consent of the other side advocate, I would like to mention item number 10, 11, and 12, Lordship. Today, Mr. R. Puzari has some difficulties, Lordship. He is led in this matter, Lordship.
Okay.
May I please, Your Lordship? In item number 12, my lord, I'm for the petitioner, my lord. The date may kindly be fixed, my lord. On 20th.
Who is for? No. That will depend upon the calendar of the court. Who is the petitioner in item number 10? Anybody present on his behalf? We have informed.
We have.
Okay, Miss Z.
Hajar.
Hajarika, Learned Standing Counsel. Miss Z. Hajarika, Learned Standing Counsel, Revenue and Disaster Management Department, has made a request for adjournment on the ground that Mr. R. Pujari, Learned Standing Counsel, Revenue and Disaster Management Department, who is holding the brief, has personal difficulty today. Has made a request for adjournment question. It is submitted that consent has been taken from the Learned Counsel for the petition to make the request for adjournment. Ms. M. Borman, Learned Junior Government Advocate, for the other state respondents. He is in attendance. In view of the prayer request for adjournment. Also, in view of the above, the request is allowed. Lays the case on so and so. Same, Likibo. Who is petitioner in 11? Anybody is there? Same order. Miss?
I mean, item 11, the petitioner.
Your name, please.
N. Kumari, on behalf of
N. Kumari, Learned Counsel.
J. Roy.
On behalf of Mr. J. Roy, Learned Senior Counsel for the petition, and Ms. M. Borman. State Council for the other state respondents, huh? Same. Then 12,
Yes, Lordship.
same, Miss
P. Goswami.
P. Goswami, Learned Counsel for the petitioner is an M. Borman present. List the case, same date.
17 September, 1709.
Give you.
Please, Lordship. Lordship, praying for listing for writ petition, my lord. My lord, in this case, my lord, last posting date of 18/6/2025.
Admission matter,
No, my lord, motion matter, my lord.
motion matter.
Yes, my lord.
What is the subject matter?
Subject matter, my lord, compensation for demolition of petitioner's house from the land, my lord.
Maybe next week,
Any date, maybe.
maybe next week.
Please, Lord. My lord, in item number 1 to 8, my lord, otherwise we receive instruction and affidavit is being prepared, my lord.
Hmm.
I am praying only for a week, my lord. It come up only for a week.
For the offer. Who is for the petitioner? Anybody?
Yes, dear
Mr. B. B. Sharma. Okay, present. Mr. S. Setial and Senior Standing Counsel in Income Tax Department has submitted that he has received the necessary instructions to file the counter affidavit and he needs, okay, I'll give you 2 weeks time. What? 2 weeks time to file the counter affidavit on behalf of the respondent income tax department authorities. He has therefore sought listing of the case after 2 weeks. The request made on behalf of the respondent IT department authority is accepted, leaves the case on so and so. The interim order passed regular shall continue till the next date of it.
I'm deeply.
10 September, 1009.
Same,
Item number 1 to 8.
1 to 8.
May I please, Lordship. Lordship, I'm praying for listing of IA. Lordship, we have filed this IA to strike out the respondent,
I is for what?
striking out of respondent 11 to 42. It was listed on 26/6, but it was left out. Therefore, Lordship may kindly,
Okay, give it to the court master.
Lordship may kindly fix any date next week.
Sir, give it to the court master. He will assign a date.
May Lordship, praying for listing of a writ petition for admission, Lordship.
Okay, give it to the court master.
Of the-
What is your subject matter?
Lordship, apart from the petitioner, some other person's names were included in the Namzari. So for that deletion was applied but not deleted, your Lordship. Of the-
May I please, your lordship, I beg to mention for listing of a writ petition. The matter is
Motion.
pending for admission. The matter is pending for disposal, your lordship. Kindly fix a
What is
date.
your subject matter?
Pertains to unfair panchayat
Huh?
election matter. Pertains to unfair panchayat election.
Unfair panchayat election.
Yes, your lordship.
Give it to the court master.
Lordship.
Supplementary list for motion. Item 15.
Mr. Das, you have not given that. address.
Yesterday only I have sent, but unfortunately the mail was not received. Today also I have sent.
Because I could not sign the order.
No, I'm sorry, Lordship. I have sent yesterday only.
May I please, your lordship. My lord, here petition number 1 is the wrongful Gaon Panchayat, lordship. And who represented by the petition number 2, lordship. Lordship, what happened, lordship, in this case? Lordship, due to recent delimitation of the boundaries of the Gaon Panchayat, lordship, the wrongful Gaon Panchayat have no office, lordship. So, lordship, on 10/1/2026, lordship, one Gaon Sabha was held by the local villagers of that GP, lordship, and identified a plot of land which was a government hash land, lordship. The Gaon Sabha proceeding is at page 22, lordship. And accordingly, lordship, your
It is
lordship,
not government caste land simpliciter. According to you, it is allotted in the name of some department.
Water Resource Department.
No, lordship, it is never been
Actually,
allotted, lordship.
It was a dike, it is a dike, Lordship. It was constructed in the year 58-59 as per the instructions which I have received, Lordship. And moreover, Lordship, the petitioner himself has admitted, Lordship. Lordship may kindly.
The portion of the land, lordship.
This is the letter which petitioner has written to the
If it is a
block
dike,
development
you
office.
cannot set up that
Lordship,
office. Simply,
yes, Lordship.
you go there and set up the office. Compliance with direction and cancellation. Secretary. 29, it defines the following regarding cancellation. What is the order?
Lordship. Order, impugned order is at page 41, Lordship.
Look at your letter. Look at your own letter.
My lord,
The petitioner has first constructed the house in the name of Water Resource Department in that type. When objection was raised by the Water Resource Department, he had changed the name of Water Resource Department and taken instead of Water Resource, he has put the name of that Rangpur Gaon Panchayat as per the instructions which I have received, Lordship.
So, as per this letter, I
He
think
have-
you are not taking any action.
No, he has
my lord,
written,
my contention is only that, Lordship. That letter was issued by the secretary, Lordship. He is the official.
He is a government official.
Yes, Lord, government officer, Lordship. So he sought time, Lordship.
He will
So-
not act irresponsibly.
He is responsible, Lordship.
He is always responsible.
Yes, Lordship. But
Right.
my contention is that, Lordship, initially a land occupation certificate was issued, Lordship, and subsequently unilaterally, Lordship, without hearing us, Lordship. That
Where
was
is the
cancelled.
hearing when it is a dike? If it is dike, suppose, if their contention is right, if it is a dike, suppose, right? Then where is the question of hearing then?
My lord, there is no dike, Lordship. That is, for that purpose, Lordship, hearing is required because a portion of the land, because a major portion of that land, Lordship, already acquired by the Bharatmala project.
No, see the situation in Upper Assam.
yes,
If you go on playing with dike
No, Lordship.
and all,
Yes, sir.
right? If the court allows, if he has made a statement,
Yes, sir.
then it is a statement received on instruction. So if you play with a dike, then the situation,
It shouldn't be,
consequence will be
yes, sir, very dangerous, Lordship.
very dangerous.
Yes, Lordship. But
It is serious matter.
yes, Lordship. Of course. So a necessary inquiry is required because, Lordship, as per my
It should
instruction,
not
Lordship.
is at this stage. But based on this letter, so I hope Mr. Das will not take up for 10-15 days.
no, yes, Lordship. That the letter issued to the BDO, Block Development Officer.
Okay, we can keep it. Your president is out of station.
Yes, sir. Because otherwise, Lordship, where from the office will function, Lordship? That is also.
That
have
is
written that in the letter
that
itself.
is for responsibility of the Panchayat and Rural Development Department,
Yes.
right? That they will take care. But so far as your location,
Yes, Lordship.
locating your Gram Panchayat office
Yes.
in a dike land,
Yes.
that court will not.
Not exactly not on
Permit.
dike, Lordship. Yes. Because major portion of that dike already acquired by the Bharatmala project. And some portion.
No, you are not to decide
Yes, Lordship. Of course, Lordship.
on that, whether it is a dike or not.
Yeah.
It is the which department?
Water Resource.
Ah,
Department.
Water Resources Department, they can decide that it is a dike or not, and the Revenue Authority. You cannot decide just because there is a vacant place, you go and set up the office.
No, there is
Ah,
necessary.
No, it
communication.
is there in your communication. Let us see.
Yes,
Mr.
But
Let us see in your communication, sir. It is not that it is khas land simpliciter. Somewhere it is there. Where it is? Mr. Page? You knew beforehand that it is a plot of land.
And in this letter on 29/7/26, they have assured that they will shift the office to Barak Srishti Hat, second floor.
I have seen somewhere. Somewhere I have seen. Come to page 34. It is for running a temporary GP office. You sought permission for running a temporary GP office. Then you went there, set up the office.
My lord,
Now you want the land.
my lord, because lordship, page 28, lordship, because there are so many communications were made from the BDO as well as local authorities, lordship. In page 28, lordship, page 28.
Now you want the land.
Page 28, lordship, for establishment of Rangpur Panchayat, that land was sought, lord.
Whether it was granted.
Lordship, initially that land occupation certificate was granted, lordship, in favor of the.
Somebody unauthorizedly grants land occupation certificate. Shall we accord our approval there? Let us see from first one itself. You ask for, wrote to the deputy commissioner to set up the office, right? In that land. Okay, then 18, 19, and 20. Then 21. That is your letter.
Yes.
Why the need arose? at page 21. Why the need arose to write the letter at page 21?
Yes, Lordship.
If they are not concerned, water resources, why you were writing those letters? You knew beforehand. Where is your 23/12/2025 letter? Come to page 28.
Page 20. Lordship.
Additional District Commissioner. Where is your letter 30/01/2025?
30/01/2025, Lordship, there are no letter perhaps. Or
Now come to page 34. There, the first time, video says for running temporary GP office. There, with reference to the subject cited above, I have the honor to submit herewith the letter as received from President and Secretary of Rangpur Gram Panchayat, while letter under reference to, that is 30/01/2026, for seeking permission for running temporary GP office of Rangpur Gram Panchayat at so-and-so near Madhurapul Clock Tower. Then look into the matter. Cancel. Now, what is your resolution? These two are contradictory. Secretary's letter
Yes, Lordship.
dated 29/7/2026 and your resolution
Yes, Lordship.
at page 42 are contradictory. You have confirmed instruction, Mr. It is Dike.
Yes, Lordship. I have confirmed instructions, Lordship. It is like, and it was constructed in the year 1958. The length of the dike was 14.977 kilometer. I have got the instructions.
Yes, Mr.
My Lord,
Borvia.
my Lord, excluding, my Lord, as per my instruction, Lordship, excluding that dike, Lordship, that 10 khatas land was, Lordship,
Now,
available.
Mr. Borvia, you cannot, if this statement is correct,
Yes, Lordship.
you cannot make contrary submission. Right. Here in the court, you make a submission in another line, whereas before the authority, you are singing in a different line.
Yes, Lordship. My lord,
Which one is to be believed?
my lord,
Verbal or in writing?
in writing, Lordship, but fact is that, Lordship, the secretary being the government official, Lordship, he is, Lordship, bound by the decision of the authorities, Lordship. That's why he perhaps wrote that letter, Lordship, seeking some time, Lordship. But the office, Lordship, for
Take your call. Otherwise, if this is correct,
which one, Lordship?
this letter is correct,
Yes.
and you have decided to relocate. If this is correct or not, take your call. Otherwise, you will take a call.
So, Lordship, so far as my instruction, Lordship, there are no decision in the Panchayat
But
letter.
even if we issue notice, nothing of any interim nature. Because if it is a land as per instruction, dike land, nothing could be.
My lord, for the time
Because
being, Lordship, because, Lordship, otherwise
It
the
is
office will
reflected
be.
from the letter of the, which the executive engineer has written to the circle officer also, Lordship. I've got the printout.
See the devastating consequences.
Yes, Lordship. But
We cannot ignore all this just for setting up a panchayat office. What is that? Mathurapur, right?
Mudrapul.
Something Mathurapur.
Mudrapul.
Just a minute.
Dike along left bank of Mathura
Ah,
from Khoril tea state to outfall of Barak.
somewhere it is written in the
Yeah.
land acquisition certificate also.
Yes, Lordship.
Let us see. Mathurapur, full clock tower. Okay. There is river Mathura
Mudrapul.
near that.
Yes, Lordship.
What I would like to say, it has come to notice that some master on the dike. Hmm. They will surely notice.
My lord, because
Shall I say it? The executive engineer has reported that construction, erection in the name of Rangpur Panchayat Office on the dike,
Yes.
without prior permission. Illegal construction has damaged the dike, thereby causing threat to the water resources structure as well as adjoining areas. If such thing is reported, court cannot close the eyes.
my lord,
Third,
that's
Mr.
why, my lord,
NH.
that temporary GP office which was constructed, that was over the dike, Lordship. But the land whereon, Lordship, they were permitted, Lordship.
There we will
It
examine.
is 10 kata, Lordship. That's
Structure
required to
you have
examine.
to
it.
remove over the dike. No way. If you are eligible to be allotted land,
Yes,
we'll examine. But erection of structure over the dike, we will not close our eyes.
My lord, that dike already, Lordship, demolished.
You are not-
Lordship, by the authority, Lordship. Because that dike already
A
flat. Lordship.
body over the constitution.
Yeah.
You are not an extra constitutional body. You are a constitutional body.
Yes.
It is your duty
Yes, Lordship.
to save the art
Lordship.
and the nature.
Yes, Lordship.
And you have gone there to construct structure over the dike, which has been constructed in 1958 along river, left bank of river Mathura, to save the adjoining areas and greater Rangpur from inundation of flood water of river Mathura. Heard Mr. N.H. Borvian Learned Counsel for the petitioner. Panchayat, Where are they? You were there, Miss N. Bora, Alliance Standing Council, Panchayat and Rural Development Department for the response number 1, 3, 3, 6, and 9. G. Hazarika, Standing Council Revenue and Disaster Management Department for the response number 2. Miss M. Borman, Line Junior Government Advocate Assam for the response number 4, 5, 7. And Mr. R. M. Das, Standing House Water Resources Department for the response number 8. First of Para, the petition number 1 is Rangpur Gram Panchayat, and the petition number 2 is its president. First of this writ petition under Article 226 of the Constitution is preferred, seeking inter alia a direction, seeking setting aside and quashing of an order dated 22/07/2026 within by an annexer 13 issued by the respondent number 7, whereby an occupation certificate issued earlier on 3/3/2026.
Well, that was wrongly written 3/2/2026.
3/2026 in favor of the petition number 1 has been cancelled, first off, by the on 3/2/2026, the respondent number 7 had provided information to the effect that a parcel of land measuring 10 katha under our second RS government khas dag number 15/797 within bracket PT, Moja Rangpur Part 2, Pargona, Borak Par, page 25, is reported to have been lying under the occupation of the Rangpur Gaon Panchayat office. Post of such information was provided to the petition number 2 as per her prior petition dated 3/2/2026. It is a case of the petitioners that after the limitation, Rangpur Gaon Panchayat did not have any permanent Gaon Panchayat office. Post of requests were made to the district revenue authorities from time to time to allot a plot of government khas land. Post of on 3/12/2025, a a representation was submitted highlighting that was submitted before the respondent number 4, highlighting that a plot of government house land, the subject land. I got one. It is paragraph 3, which originally belonged to erstwhile E&D department, within bracket presently Water Resources Department. You knew had remained unused for decades because it was a dike. And the subject plot be allotted to the petitioner Gram Panchayat for setting up for construction and setting up its office post. In course of time, during the subsequent period, the petitioners set up a temporary Gram Panchayat office on the subject plot with bamboo fencing. And on the occasion of Republic Day, the temporary office was also inaugurated. And since then, all official works of the Gram Panchayat are being conducted from the state office. Post office. It is stated that the land occupation certificate was issued thereafter by the respondent number 7 on 3/12/2026, which aimed to be arbitrarily cancelled by the impine order dated 22/2/2026. Post office. On the other hand, it is the contention of the petitioner, Mr. Das, Land Standing Council, Water Resources Department, that an embankment, quote, dike along L/B of Mathura from Horil TE to outfall of Borak, unquote, was constructed along the left bank of river Mathura with the objective to protect Greater Rangpur and its adjoining areas from inundation of flood water of river Mathura. Post op. On 10/6/2026, the respondent number 8, by his official letter of event to the respondent number, to the circle officer, Silsor Fodor Revenue Circle, brought to the notice that construction of structures in the name of Rangpur Panchayat Office, construction was made in the name of Rangpur Panchayat Office on the dike without prior permission from the Water Resources Department, and such construction had damaged the dike, thereby causing threat to the water resources structure as well as the adjoining areas. Full stop. It was highlighted that if the structure was not removed from the dike, the obstruction might be a cause for any disaster in near future. Full stop. A request was made to take necessary steps in order to remove the illegal structure from the dike at Rangpur area so as to avoid any disaster-like situation. Full stop. Para, it is. Continue. Mr. Das has asserted that the construction of the Gram Panchayat of his has been made not only without permission of the Water Resources Department, but also on the dike. Full stop. No matter of he has further mentioned that by a letter dated 29/7/2026, the Secretary of Rangpur Gram Panchayat has written to the respondent number what?
9.
Nine. Assuring that necessary action will be taken in response to the direction made in respect of the subject land and demolition of the existing structure so as to shift the office of the Gram Panchayat, so as to shift stroke relocate the office of the Gram Panchayat to another place. Post of a matter of regular consideration issue notice or returnable on so as so and so is appear accepted. No formal notice, extra copies within 2 days from today. Having heard the learned counsel for the parties. On the interim prayer. And upon considering the facts asserted on behalf of the respondent Water Resources Department, that the construction of the office is made on the dike, which could be a cause for a disaster in near future, no interim direction. To restrain. No interim direction. As sought for. Is called for.
1109, 11 September. Item 16.
The documents placed by later dated so and so. And দুখন কাগজ are kept with the placed by Mr. Das, standing counsel so and so, are kept with the case record. Legal for expeditious consideration of repetition, the respondents shall bring their stain invariably on or before the returnable date. Yes.
16.
May I please, your lordship? My lord, the petitioner before my lordship is the Tejpur Idgah Committee, my lord, represented by its president, My lord, this is a very, my lord, age-long religious institution for the purpose of, my lord, to use the Eid prayers, my lord. And a land had been allotted, my lord, long back in the year 1923, my lord. If my lord may be pleased to turn to page 87, my
Well,
lord.
let us see first your prayers.
My lord. Starts at page, my lord, 79,
Prayers.
my lord.
79. So you have written 79 pages repetition.
My lord. My lord.
Okay.
My lord, facts are so long, my lord, that's why, my lord.
What is this PIN?
My lord, a PIL had been moved. My lord, that order we have also annexed, my lord, at page 166, my lord.
166.
Yes, my lord, the operative part. The last paragraph, my lord.
166.
Yes, 166, my lord. We accordingly direct the respondent number 3 to use the land field only for the Eid prayers and
Which
immediately.
one? Which one? Page?
My lord, page 166, the last
We
paragraph.
accordingly,
We
okay.
accordingly, my lord.
Respond, who is respondent number 3?
My lord, huh? My lord, this committee, this
Okay.
committee, the present petitioner.
Okay.
My lord. Use the so and so for Eid prayers and immediately remove both the sets which have been raised by it without any permission from the authorities. We also direct the respondent number 3 not to prevent the public from using the field for morning walk, etc. We make it clear that if the respondent number 3 on its own fails to comply with our order, the district authority shall ensure that the above directions are complied with in the public interest. And the number 3 will be at liberty to apply as per law for making any construction before the appropriate authority, and the appropriate authority shall decide the application on its own merits.
The status and so. So, sir, I will not be able to explain
My lord,
what a division bench had meant by etc.
my lord,
Is it not? Single judge
my lord,
cannot explain
my
what
lord,
the division bench had meant by etc.
my lord.
First prayer, it is only division bench of equal strength can explain all this.
My lord, it is a, my lordship can judicially.
No,
interpret,
absolutely not. So as an authority that single judge can sit over
my
the
lord.
wisdom expressed by a division bench.
My lord,
So as any authority, even from House of Lords also. Not to speak of Honorable Supreme Court,
my lord, my lord.
American law, English law, that single judge can explain the meaning of etc.
My
expressed by a division bench.
My lord, actually, we are not against the
No,
abstract also.
and
my lord. We are also not against
if the
abstract.
first thing, no,
My lord,
okay, you submit,
my
I
lord.
have my own view.
No, no, my lord, we can.
And when
only-
one of the prayer
My lord.
is not within the single bench,
No, my lord, we can only pray before my lord, my lord.
we can also express
My lord.
first one.
First prayer, my lord. First prayer.
We cannot disintegrate the prayers then.
My lord. Because, my lord, the situation is so.
My position is that I cannot send it to the division bench also.
My lord, my lord.
I have only one option in such situation.
Yes.
If, right, I cannot, because English language is, say, the word sorry,
My lord.
the word etc.
Wide meaning, my lord.
So it is for the division bench to explain. If that division bench is not available, then another division bench
My lord.
of equal strength.
Same strength, my lord.
For me, it is difficult. Because the direction was to you.
Yes, yes, my lord.
So you have to get it confined, what is etc. means, what etc. means. This is my limited understanding.
No, no, my lord, my.
So I may be wrong. Then what is the prayer?
My-
Implement and give government orders. So and so.
Getting to understand, my lord, Bihu committee is organized as a Bihu in Assam. And they want to prevent that, my lord.
No, 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 absolutely not, my lord. Absolutely not, my lord.
The
There
land
a-
is
my
not
lord-
yet settled, my lord.
My lord, the arrangement which had been made in consultation with the committees, there is an arrangement had been made and government policies are also there. That in what nature the Bihu should be
By
organized.
the divisions means everything has been limited to you, made limited to you, if I have understood.
No, my lord, they limited to
Made
me,
limited to
my lord. But the
Huh.
arrangement which has been
to
made by
use
the
the
government,
field,
my lord.
land and field only for Eid prayers
Yes, my lord.
and immediately remove both the seats.
Yes, my lord.
Some seats may be there,
My lord.
which have been raised by it without any permission.
That
We
was the
direct response number 3 not to prevent the public from using the field for morning walk, etc.
Settle one, I could. ঠিক আছে সিহঁতৰতো ঈদৰ টাইমত প্ৰিভেন্ট কৰা নহয়
My lord, we are not opposing Bihu celebration or anything.
Where is
my lord. My lord.
where is that your gate has been locked? Because at 10:30
Yes,
yesterday, if I
my lord.
remember correctly,
Yes, yes, my lord. The
where because I granted permission to
Permission.
you on an
Yes,
off
yes.
day
My lord.
on the ground that your gate has been locked. Where is
Lord,
that pleading?
My lord, it has been missed in my pleading, but it is one gate.
Sir,
locked, my lord.
I distinctly remember
My lord, I made the mention.
you made a mention
Yes,
at
my lord. Yes, my lord.
10:30
My
that that this gate has been locked.
My lord.
Idgah committee, Moidan or garden.
No, no, I made the mention, my lord. It is on record, my lord. Because
We
it
can
is-
see, and then I
My lordship allowed
gave you
today.
permission on an off day.
No, no, my lord, yesterday I make the mention.
Off day. Today
Yes,
is not motion day.
motion day, my lord. That is correct.
Because you said something about locked gate.
Absolutely, my lord.
Where is that pleading?
No, my lord, that pleading. My lord, the lock, once, my lord, the
Where is that pleading?
pleading starts,
No, that gate has been locked.
my lord.
See, on making another submission
My lord,
for listing on an off day.
my lord.
Right, where is that?
My lord, that pleading is not my friend. has
Mr.
listed,
As
my
a
lord.
senior counsel, you should have,
No, my lord, I
you
will,
should not have this.
my lord, it is.
And otherwise, making a prayer for listing,
Listing, my lord.
generally, a senior counsel, it
No,
is
my
not,
lord, what my friend. has
the
missed
Supreme
it.
Court has clearly restricted it.
My lord.
And you have said that the
No,
gate
my lord,
has been locked.
I can bring those evidences on, my lord.
You,
My lord, kindly-
Mr. Yeah, this is not appreciated. If there is no pleading,
That is correct, my lord. I have
right?
also
You
checked.
made oral submission.
My lord.
Taking cue from your submission, I permitted to get the matter listed on an off
My lord,
day.
I do not deny, my lord. I made the submission.
This is not, I'm not in favor of this kind of practice.
No, no, my lord, my lord,
This is, where is the statement that gate has been locked?
my lord, that statement starts at page.
Though I don't have many memories, I at least remember the submission made by senior counsels.
My lord, yesterday I make the submission.
Yes.
Yesterday, my lord. And
So,
I am not, my lord,
at least
my lord, I am not denying.
24 hours,
No,
I
my lord,
retain.
I am not denying, my lord. I can bring that on.
No,
additional
that is
affidavit.
different matter, mister.
My lord.
That
No,
is
no.
different matter,
My lord, my lord. It is missed, my lord. In the pleading, it has been missed out, my lord.
right?
Inadvertently missed out, my lord. Not intentionally, my lord. It is there, my lord.
That is not,
I-
if you have not seen vetted the draft, don't make such prayer.
My lord.
Why should we continue with this?
Lord, I can, my lord, if my
That is
lord.
not that piecemeal. Is it an EMI plan?
No, no, my lord,
This is not Correct.
My lord, it is inadvertent
I
mistake on
I
our part,
don't
my lord. I seek
like
ap-
this practice.
but I seek apology for that, my lord.
I don't like this practice.
Should not, my lord, but it happens, my lord.
There is no specific
My
pleading.
lord, from paragraph 45 onwards, my lord, we have made the.
What is the cause of action? There is a division
Yes,
based judgment.
Yes.
What is the cause of action? Please
Cause-
tell me.
Cause of action, my lord, starts from page 45, my lord. Page 61, paragraph
What
45.
are those you have mentioned in prayer number 2?
No, para number 2, my lord. is
Prayer
the-
number, prayer number.
Prayer number 2. My lord, to direct the authorities to strictly implement and give effect to the
What
government.
is
of-
this?
Because
What
these
is
are the
this
orders.
government order 1975?
Yes, my lord.
Item 17.
Grievance is regarding some compensation, right?
Yes, Lordship. I want to place some photograph, Lordship.
Mr. Das,
My lord, affidavit has been filed, my lord. It says, my lord.
but I find some calculations were there in your document. Some calculations were there in
My
your
lord.
document
My lord.
that that is running page. This page 80, 90. This building was at Dag number 919.
Yes, Lord. Yes.
Mr. Das, the scheme, page 80. Now, it is an admitted fact that the building, a part of the building is affected.
Yes.
Now, kindly come to page 80. You have a formula. You have a formula,
Yes,
page
madam.
80.
Yes, madam.
Now, let us see page 90. 919. He is entitled for Jirat
Yes, madam.
for that structure,
Yes.
right?
Yes, madam.
So that is missing. Neither in 919 nor in 913. That structure is missing here. What is the full? What is the full? Do you have the full copy? Or
No.
Mr. Das should have full copy.
This,
It is
this
half page 90.
90, yes, madam.
Uh,
919.
on the extreme right,
Yes, madam.
the figures are missing.
It says, my lord.
No, it is half. The total amount is missing. Page 90. Because Zirat value, there is nothing. Banana tree.
No, my lord. Solatium 100% on Jirat is there.
No, where is the figure? If the assessment,
Additional.
if the assessment,
Yes, my lord. That is missing.
that is missing. And this assessment of this thing,
3 houses access.
no, that your executive engineer, page 97. 97. Or more detail somewhere else. Page 104.
104 is there, madam.
That is the, for GR assessment, these
Yes,
are
yes.
to be assessed. And page 97, he perhaps assessed at 1,30,254. Page 97. And this has to be, Solicem is to be added there. All these are to be added there. It would go to another amount. It will be increased to another amount. Because by the formula,
My lord, what I want to submit, my lord, there might be some discrepancy. That I'm not denying this. But he should have accepted the amount given. And he can prefer an application under, or he can go for reference regarding his.
where is your scope for reference in this case, direct purchase? Show us.
Yes, yes.
Show us.
It's a negotiation settlement, my lord.
Uh-huh.
What I'll do, my lord, can I get the,
No, what we can do, page 80, direct purchase price, the
Yes.
formula is there,
yes, my lord.
right?
Yes, yes,
And while assessing Jirat compensation, this structure got dropped,
yes,
assessment,
yes, yes,
right? A figure has been arrived at.
yes, yes,
So, as per the formula, calculate
yes,
and whatever is entitled to the petitioner
yes,
for the structure as per the formula
yes,
under your scheme,
yes, yes, yes,
get it done
yes, yes, yes,
within a period of 3 months.
yes, yes,
If he still agrees,
yes, yes,
he
yes,
will come.
yes,
If
yes,
he is satisfied,
yes, yes,
matter closed.
yes, my lord, yes.
Because we'll ask for,
Again,
they
it
will
will take
again
time.
take 6 months.
Yes, my lord. It'll take time.
What do you
Again,
say?
This will be better, my lord. If they agree, they can come. My lord. Only time frame, that will help them also.
3 months. Heard Mr. G.G. Gogoi, learned counsel for the petitioner.
Yes, sir.
Ms. E. Hazarika, learned standing counsel, Revenue and Disaster Management Department for the respond number 1. Ms. M. Das, learned standing counsel, Public Works Department for the respond number 2. And Mr. N. Das, learned Junior Government
326.
Advocate, Assam for the respond number 326. Closed. Para. The Buparam is alive or dead?
Alive.
Alive. Okay. The petitioner is a son of one late Buparam Pachani. He stated that Buparam Pachani,
Lordship, kindly, not late, alive.
oh, one Sri Buparam Pachani. It is stated that Buparam Pachani along with Suti also. He is Suti also.
Yes,
Huh? Buparam Pachani at বুঝতে পেরেছে Chutia is a co-patadar of 2 plots of land Roman 1. What is your agreement? 60. 69. 60. One. You said about the area.
Yes, Lordship. For less.
Or 2 plots of land measuring outside room 1. 1 kata 5 lessers. Covered by DAG number 919 under periodic pattern number 99. Semicolon N. 2. What is the other part?
911, my lord.
Area. Subject plot 1.
19 less.
19 lesser. Covered by DAG number 913.
919. 919.
No, 1 I have already said. Because of
911.
this page
911.
90.
Yes, 911. 911. One is 919 and one is 911.
But page 90 it is 913.
Really?
Hmm?
Wrongly.
Okay.
911.
2 plots of land.
911.
2 plots of land under different DAG number and periodic pattern number at Revenue Village, Deulia, Gubinpur Gaon, Moja, Mashkhwa, Thokua Revenue Circle District, Lakhimpur, Assam. Postal. It is the other co-patterners are Narayan Sutia and Moneswar Sutia.
Yes.
Narayan Pasani at Sutia and Moneswar Pasani as Sutia. Full stop. Both the plots are parts of both the plots of land came to be acquired okay, under DAG number 919,
Periodic
within
pattern
bracket part,
34.
covered by DAG number 919 part under periodic pattern number 99 and DAG number 911 part under
34.
periodic pattern number
34.
Parts of subject plot 1, subject plot 2. Parts of both the subject plots came to be acquired for the purpose of a project, quote, construction of Thokua Butikur, Tiniali to Teliajan Road, under Assam Mala project by the respondent authorities. Through the scheme quote, land acquisition through direct purchase by way of negotiated settlement, unquote, notified by the Public Works Roads Department, Government of Assam, by the notification dated 20/01/2021, which was published in issue number 53 of the Assam Gazette, which was published by number 53 in the Assam Gazette in its issue dated 22/01/2021. Full stop. Para. It is the case of the petitioners, though two agreements were executed by all the partners of the said two subject plots with a requisition agency on 5/4/2022, disclosing the amount of compensation assessed for acquiring parts of the two subject plots, it came to light subsequently that a structure in the form of a house standing on subject plot number 1, that is subject plot number 1 within bracket tag number 9119, was missing from the GRAT value. In the compensation statement, prepared by the respondent authorities in respect of the acquired lands for the project. Full stop. As per the two agreements, an area of land measuring 19 lessers from subject measuring 4 lessers within bracket 0.0132 acres from subject plot number 1 and area of land measuring 19 lessers within bracket 0.0627 acres from subject plot number 2 have been acquired and initially agreements, in the agreements, the payment of compensation representing the market value of the land, including value of the immovable property stroke assets attached thereto, and the value of standing trees and crops, solatium, etc., were assessed at rupees 48,732 and rupees 16,05,323.83 respectively. Post. When the compensation statement, when the petitioner came to know the details assessed under different heads from the compensation statement. কি করলো একটু? Details, details, the amounts assessed. Amount assessed under different heads from the compensation statement. The petitioner came to learn that no assessment was made for the house standing on subject plot number 1. Full stop. Only a Zirat compensation. Compensation, Zirat compensation was assessed only for 10 number of banana trees in connection with banana trees at 3,600 in connection with subject plot number 1. Full stop. The petitioner had thereafter represented before the respondent authorities to assess the Zirat compensation for the house standing on subject plot number 1, comma, which for some reason got dropped while assessing Zirat compensation for subject plot number 1. Full stop. The petitioner had claimed that the house existed on the subject plot number 1 is of RCC construction. Where it is mentioned that it got dropped or it was assessed somewhere, 911 or something like that. Your affidavit, Mr. Das?
My lord. 97.
Huh?
104.
Para.
104.
In the affidavit in opposition
65.
filed by the respondent number 3, 4, 5, and 6. Apart from asserting that the landowners of the two subject plots had willingly executed the agreements
104.
in Form B, has further averred that the compensation amounts were calculated as per the provisions of the scheme, comma, land acquisition through direct purchase by way of negotiated settlement, comma, notified by the notification dated 20/01/2021. Full stop. It is stated that the Public Works Department had assessed the house of the petitioner's father, comma, which is a Assam type building, and submitted a valuation report, comma, which was approved by the competent authority on 31/3/2022. Full stop. Compensation statement was thereafter prepared for further processing and disbursement of the compensation amount. Page 61, para 6, it is mentioned. Full stop. However, the petitioner submitted an application on 2/1/2025 before the respondent number 3 and the respondent number 4, or before the respondent number 3. Wait, what is 2/1/2025? Whether it is part of your petition? Sir Gogoi?
Yes, Lordship.
2/1/2025.
Yes, Lordship.
The letter is part of your petition.
Yes, Lordship. Annexure is.
Page.
Is. Include RCC. Include RCC.
To include the house structure standing on the subject plot number 1, and also to increase the compensation amount. Full stop. On receipt of the said application, comma, the respondent number 4 by notice dated 17/3/2025
94.
asked the landowners of subject plot number 1 to attend a hearing scheduled on 21/3/2025 along with all the relevant land records. Full stop. Accordingly, comma, hearing was conducted in presence of the affected landowners of subject plot number 1 and the other concerned officials involved in the process. Full stop. As the landowners expressed discontent regarding the compensation amount reports regarding assessment of Jirat was called for. And on 29/5/2025, comma, the respondent number 4 held another hearing. A joint verification was thereafter conducted. Please point out, if I go wrong factually.
Report is.
By the executive engineer, Public Works Department, Lakhimpur District Territorial Division. As regards the valuation made in respect of the subject plot number 1 and submitted a report which stood forwarded on 31
12.
Again, then it is there, it is in record, right? Because dates will be
31.
in jeopardy. Where is that report?
Page 96.
Giving a valuation of the house, stating it to be a Assam type building, at 1,30,254. Contrary to a claim made by the landowners or owners that the house standing on the subject plot is of RCC construction, the Public Works Department had reported that the house was not actually RCC construction as it did not conform to the specification of RCC building. It is there already done, 3,41,000.
Yes, sir.
It is done.
It is done 3,41,000 during the pendency of the report, but sir, I can produce some photo uploads. I already produced some photo uploads.
No, we cannot, for that we cannot
There is not
examine in writ petition. If any forum is available, you can go. But we are not here to increase your compensation. Writ remedy is not for. That is why I wanted to find out from Ms. Borman whether there is any forum in the scheme. No. There is no arbitrator, no reference to. Huh?
Page 73. Settlement board settlement has been used.
Because it is consensus. 70?
73. 4.17. 73, 4.17. Step 17.
But that is not the. You should not have entered into those agreements.
Then
In Form B.
Then it can be acquired.
You cannot approve it and reprove it. You cannot change your stand. First agree, then disagree. Where is the 21/10/2025 letter?
21.
10/2025. which is annexed as annexer to paragraph 10.
$99 crores.
Uh, Aforesaid has been added, right? The para in the affidavit in opposition, comma, of the respondent number 3 to 6. It is specifically averred that after adding solatium the amounts towards solatium, what will do, Mr. Das, is 72. 4.8, 4.9, 4.10, and 4.11. Right. Page 72.
Yes, yes.
And the formula. They will disburse this 3,41,000 along with a compensation statement. Compensation statement.
Compensation, yes.
Strictly as per the formula.
Yes, yes. Yes.
And while preparing the compensation statement to be communicated to the petitioner,
Yes.
strictly as per the formula,
Yes.
if any amount, any additional amount is found due, then same shall be disbursed.
Yes, yes. Yes.
Right?
Yes, yes.
That will, because we are not going to do
Yes,
that
yes,
form,
yes.
right?
Yes.
Is last word to call hol, last line to. That when the amounts towards solatium, comma, additional compensation at 25%, and I think interest at interest at 12% are added to rupees 1,30,254, comma, a final compensation and an amount of rupees 3,41,265 can be arrived at as a final compensation for the structure standing on subject plot number 1. Full stop. It is further mentioned that the final compensation amount could not be processed and disbursed to the landowners as they have not submitted the required documents. Full stop. Para. By in the state government has notified the scheme, land acquisition through direct purchase by way of negotiated settlement for acquisition of land for improvement and upgradation of state highways and major district roads under the Assam Mala program and the externally aided projects. For acquisition of land in an expeditious manner for expeditious acquisition of land for speedy implementation of the programs. The steps and features of the scheme have been laid down in the notification dated 20/01/2021. First of for the case in hand, the following steps are of relevance. Page 72, 4.1 to 4.11. In clause 5 of Annexure P to the scheme, land acquisition through direct purchase by way of negotiated settlement, unquote. A formula to arrive at the price of to arrive at direct purchase price is mentioned. Full stop. As for towards direct purchase price, the landowners get an incentive of 25%, inclusive of relief and rehabilitation benefits, on the compensation calculated as per the provisions of section 26 to section 30 of the full form to DDO RFCT LARR Act 2013, valuation of immovable assets and Schedule 1 of RFCT LARR Act. First of the direct purchase method is stated to be all encompassing and inclusive of all compensation and rehabilitation and relief benefits, as specified in the second schedule of the RFCT LARR Act 2013. First, para. As per the respondent authorities, as per the stand taken by the respondent authority in its affidavit in opposition, the landowners are entitled to receive an amount of rupees 3,41,265 for the structure existing on the subject plot number 1. Full stop. On the other hand, comma, the petitioner has canvassed that the landowners are not satisfied with the said amount of compensation of rupees 3 lakhs so and so, as it is not adequate. Full stop. Para. From the scheme, comma, land acquisition through direct purchase by negotiated settlement, comma, it is noticed that the acquisition process, in the acquisition process, is to be proceeded with a pre-informed manner. Full stop. Since the petitioner has contended that no compensation amount, no compensation statement as per the formula for calculation of direct purchase price has been disclosed to the petitioner stroke landowners, and the detail and the manner in which the amount of rupees 3,41,000 so and so has been arrived at,
Calculated.
comma, this court is of the considered view that any compensation amount for the structure existing on subject plot number 1 has to be strictly in accordance with the direct purchase price formulated in the scheme and full stop there, and a landowner is entitled to receive a compensation statement along with the amount of compensation assessed for either his acquired plot of land, either his plot of land which has been acquired, or for any structure which existed on such acquired land. So therefore, the petitioner is also therefore the landowners of subject plot number 1 is also entitled to get a compensation statement for the structure existing on subject plot number 1, which must be in strict conformity with the direct price, which must be calculated strictly in conformity with the formula for arriving at the direct purchase price. Post up. In the above view of the matter, comma, this court is of the considered view that instead of keeping this writ petition pending, the same can be disposed of with a direction to the respondent authorities, more particularly the district commissioner.
Yes.
As per number
3.
to disburse the amount of rupees 3,41,000 so and so, along with a compensation statement. Uh, giving details along with a compensation statement prepared to that effect stringly as per the formula to arrive at the compensation amount to arrive at the direct purchase price. Post up. It is further observed that if, as per the compensation statement prepared strictly as per the formula for direct purchase price is higher than the amount of rupees 3,41,000 so and so, already arrived at, then such additional amount is also to be disbursed to the landowners. Full stop. The entire exercise is to be completed within a period of 3 months. Full stop. If after receipt of the compensation amount statement, the landowners of subject plot number 1 find themselves to be aggrieved in any manner, it would be open for them to resort to avail appropriate remedy as permissible under the law.
One more maybe added matter. They will
Huh.
they will supply
Ah,
this.
mm.
Okay.
If after after receipt of the compensation amount and the compensation statement, the landowners of subject plot number 1 shall receive the amount of rupees 3,41,000 so and so, along with the compensation statement, by completing the requisite formalities within a period of 15 days from the date of receipt, from the date of submission of a copy of this order
Certified.
at the office of the respondent number 3 by the petitioner.
By the petitioners.
Right. Full stop. If the landowners of subject plot number 1 feel itself agreed, find that the compensation statement, find any discrepancy in the compensation statement, they must receive the compensation statement under they would receive the compensation statement under protest.
Yes.
Right, that will keep
Yes,
the
yes. Keep them on somewhere.
will make the correction.
Yes, ma'am. Only they will supply the certified copy of this. Yes, I will.
3,40,000 was assured. Anything above?
Yes.
Item 18.
May please, Lord. No, see, this is regarding that passport conduct.
Can you say that you are facing a criminal case, right?
Yes,
Charge sheet submitted,
charge sheet submitted.
cognizance taken.
No, someone also has not been issued. We have only come to know from when our passport was denied.
Where is that information?
My lord,
Do you have any from the website, anything
yes, my lord.
that,
At page
because cognizance will be taken in your absence.
yes, then someone will be issued to us.
If cognizance is issued,
No, my lord, someone we have
no,
lost.
cognizance has been taken. Cognizance will be taken in your absence
Yes,
after submission of the charge sheet. Then the question,
then framing of charge and all.
no, that order,
At page
cognizance order will be there. After submission of the charge sheet, cognizance will be taken
yes, my
of
lord.
the offense
My lord,
and process will be issued to the accused,
yes,
right? Once that order is on record, now Supreme Court has clarified. That is the problem.
my lord.
Have you gone through?
That Radheshyam case, my lord.
Not Radheshyam. Radheshyam has been explained.
And
Radheshyam has been explained. Naresh Miraskar, Radheshyam,
yes,
Nita Singh. Nita Singh.
but my lord, in
No,
Yeah, sorry.
just
sorry, my lord.
so this is decided on 15th in 2024, right?
And
That Naresh Miraskar, then Suryadev Rai, then Radheshyam, and it says, because for passport section 262F,
yes, Passport Act.
that has been, Supreme Court has said, recently also, because I dealt with this issue just 15 days back. That is the case of Mahesh Kumar Agarwal, right? That 62F, for that, it is the magistrate who has to pass an order on, so that that two notifications,
Notification 570.
1993,
Yes,
2019, clarificatory, right?
yes,
So that has given imprimatur that from the court you have to take the
permission.
permission, right? That is must. In your case, that has been rejected, rightly or wrongly. I'll not make comment on it. But another judgment, this Nita Singh, followed by another clarificatory judgment, that is Pragnya Pranjal Kulkarni, right? Recent judgments. One line is sufficient. If a judicial order passed by a civil court cannot be challenged in a writ petition under Article 226 of the Constitution, a fortiori, a judicial order passed by a criminal court cannot also be challenged in a writ petition under Article 226. That is the problem. That has been clarified again.
Yes.
And further clarified that sometimes it may happen that the banks can have roster for both 226 and criminal. In that case, I can change. But otherwise, that is your beyond jurisdiction. That is a problem. And your petition is under Article 226. But that will not preclude you. And you will not be left remediless. You have to challenge that order of the judicial magistrate in a petition under 482 CRPC, or nowadays
Now it is
528 CRPC. That is also
Yes.
in Nita Khanna. Right. That is a problem. I am bound by that. It is a binding decision. My hands are tied.
I understand, my lord.
The parting observation. As and by way of clarification, Supreme Court says, we observe that neither this order of dismissal of the special leave petition or the impugn order of the High Court shall preclude the petitioner to challenge the order taking cognizance of the offence, including the FIR, and the charge sheet in appropriate proceeding in accordance with law. Right. And Supreme Court has said that it has become impetuous. Problem is that, so I can observe after having that it will not preclude, because this order, where is the judicial magistrate order?
The Lordship will find it at page 23,
That is
Annexure 5,
page 23.
last page of my petition.
Appears to be wrong, prima facie wrong. But I cannot interfere.
My lord, just writing, my lord. Police has submitted search sheet. The search sheet has not yet been placed before the concerned court. Only thing is that when it went for police verification, then concerned police station informed that we have submitted search sheet. Then we got the number and searched. It took a long time, my lord, in the trial court, because in the meantime shifting and all. My lord, then we filed it long back, taken up suddenly, and one observation that is also against the conviction. We are
No,
not aware.
this order may not be sustainable, because it says court, being a magistrate court, has no ancillary or incidental power to direct the concerned authorities to renew the passport of the petitioner. That is absolutely wrong. That court has the power to direct under section 6(2)(f) with the notification of the government of India. And the Supreme Court has affirmed that. And under section 7, that court can direct that whether for 1 year or for 10 years,
Yes, my lord.
all these are there.
These are there.
That court has the power.
Yes.
So, a coordinate bench exercising power,
And the
criminal
fact-
jurisdiction,
Yes.
they can do so. But I cannot interfere with this order.
Lordship,
I mean,
I will approach. My lord, only
So,
liberty
no,
to be granted.
better to have a
Yes. And
thing clarified so that you can have the relief.
And my lord, just
You can have the relief
yes.
appropriately. And I think it will be better to observe
Yes.
something. Otherwise,
That
you will
will be
be nowhere.
I'll be grateful, my lord. My lord, kindly one thing, my lord. This annexure 4 at page 14, that application we made before the learned magistrate. At page 20, my lord, we have enclosed all these notifications also. At
So
page
you
20.
can get it,
Yes, my lord.
get this thing order set aside
Yes.
from a bench exercising criminal jurisdiction. And your petition is under Article 2 to 6. And this has been clarified, and by all the high courts are following it now.
We oblige that.
Yes, madam. Where is passport? Passport is, where is passport? Passport man?
They file a bill.
But it has to be in his presence. You will wait for some time.
I'll call him.
If try to call
Yes,
him.
I'll call.
Since I am aware of the law, so I can observe which might go in your favor.
Oblige. No, it's a mistake on my part, my lord. I have not.
No, it's
studied
okay. Everyone, I did not know also because I handled that case somehow. So I could know. Otherwise, I
have
would
learned
not
so
have
many
known.
things, my lord. So many cases I have learned. Taken
Next,
note of all.
next.
Oblige.
Item 19.
Where is Mr. Sheikh? Where is Mr. Sheikh? He is seeking an interim order. Division bench, Mr. Pathak?
My lord.
He made submission
My lord.
before the division bench
My lord.
that so and so for the appellant submit that there is a serious apprehension of the appellants that they shall be evicted from the land
My lord.
even before the matter is finally decided. It
My
has also been submitted
My lord.
that under similar circumstances, interim orders have been passed by the coordinate benches of this court. Coordinate benches,
My lord.
meaning there are more than one,
My lord.
right?
My lord.
And where is my order?
I'm also raising a question on the maintainability petition.
On what point?
My lords, firstly, because in fact, firstly, if I may address your lordship on the similar order, the order which the petition appellant there was relying upon was passed in WPC 1793 of 2026. It was not an order of status quo. There was an observation made by the learned coordinate bench that since the settlement has already been made in favor of APDCL, the provisions of Rule 18 of the rules made under land revenue regulations would not be given effect to, because that is only for ejectment from government khas land. So, but if Rule 18 is not applicable, then definitely Section 165 of the primary regulations or the Assam Ejectment of Unauthorized Occupants from Public Premises Act, those two will be applicable. There was no status quo order or any protection granted to the petitioner in that order also.
Then I looked into that order.
My lord.
Then I added 2 more lines
My lord.
in my another order.
My lord.
Same order was annexed.
My lord.
Right. There simply at the last page, where is that order? Annexed as?
In the writ that order was that order was not is not annexed here, my lord. It is in WPC.
Somewhere it is annexed, perhaps, or placed.
It was perhaps placed. A copy may be there.
Placed.
My lord. WPC 1793/2026.
1793/2026. Last part.
My lord.
Para 11.
My lord. And that is precisely why there is an issue perhaps which needs to be decided on the maintainability of this petition. Because, my lord, once the settlement order has been made, there is a statutory alternative remedy as per the land revenue regulations before the revenue board. And without first exercising that remedy, they have directly approached this honorable court, and that too after 1 year of the actual impugned order being passed.
No challenge has been made after being evicted. I observed that after being evicted on 8/6/2025 by an eviction process, no challenge has been made in this writ petition as regards the said eviction process. The petitioners have only assailed the rejection of their applications for settlement by orders mentioned herein above, and allotment of 500 bighas of land by the respondent authorities in favor of the respondent of 5. The petitioners have claimed that they are in possession of the parcel of land mentioned in Schedule A to Schedule Q as on date, after being evicted therefrom on 8/6/2025. Then it goes to indicate that there has been a re-entry.
There is a re-entry
of the petitioners,
my lord,
in the parcels of land after being evicted by the eviction process, which is not challenged in this writ petition.
my lord.
In such obtaining facts and circumstances, the interim order sought for in the form of status quo is not called for.
My lord. And otherwise,
This is my observation.
my lord, and they admit that they are unauthorized occupants.
And before the,
May I add something? When was the being challenged? Rejection of rejection is of settlement of parts and feelings are
that I have disposed of many writ petitions.
Appellate court is there.
When there is an efficacious remedy
My lord.
and statutory remedy,
My lord.
they should have, and there is, Mr. Singh is not there, let he will again. View the position. Itu নহয়.
এইখন আছে, এইখন লগাই দিম।
That order 8/6/2025 Same epic করেছিল না তো
Page number 40,
সপ্তাহতে করেছে
48.
better not to pass any order in his absence. Mr. Sharma? Otherwise, again, there will be appeal. There could be, because he said interim orders are passed.
My lord.
I have read that order. By no means that can be
my-
termed as an interim order.
Yes, ma'am. In
of
fact, that is an
status.
order against him because by that order, he's not entitled to the protection of Salakuddin. Because that is what the coordinate bench was referring to, my lord.
There is no representation on behalf of the petitioner. Today on call, Ms. Ann Bordwell and Standing Counsel Revenue Department for the respondent number 1. Mr. A. Sharma, Learned Additional Senior Government Advocate Assam for the respondent number 2, 3, 4, 6, and 7, and Mr. K.P. Pathak, Learned Standing Counsel APDCL for the respondent number 5 are present in view of non-representation on behalf of the petitioner.
I'm sorry, Lordship. I'm
Yes.
appearing for the petition.
Yes,
Lordship, in a similar case, your Lordship passed the order.
okay. Which is the similar order?
So,
Which one?
I'm sorry.
Hard, Miss
F intensive.
F in touch. Learned Counsel for the petition. Para, Miss in touch has drawn attention of this court to an order dated 22/07/2026 passed by the division bench of this court in writ appeal number 243/2026, preferred by these petitioners, by these writ petitions against the order dated 22/05/2026, whereby the division bench dispose of the writ appeal with a request dispose of the writ appeal to consider the aspects mentioned therein, and to pass necessary orders with a further observation that so far as the present writ petition preferred by the petitioners are concerned, the writ petition will become infructuous. Full stop. Fair enough. It is submitted that the writ appeal, the concerned writ appeal was preferred by the present petitioners as appellants against that part of the order dated 22/05/2026, whereby the interim relief sought for by the petitioners in the form of status quo was declined. Close to. Para. The facts projected by these lead petitioners, the foundational facts projected by these petitioners are already recorded in the order dated 22/05/2026. The part of the order wherein observations are made for not extending any interim relief to the petitioners are necessary to be reproduced for any reference. Colon guest paragraph thing. Well. Before on perusal of the order dated perusal of the order dated 22/7/2026 passed by the division bench. It is noticed that the learned counsel for the petitioner's appellant had submitted before the division bench that there was a serious apprehension of the petitioner's appellants that they shall be evicted from the land even before the matter was finally decided. And it had been submitted that under similar circumstances, interim orders had been passed by coordinate benches of this court. Full stop. Para, it was in view of advancing submissions in such manner on behalf of the petitioner's appellant. The matter has been remanded back for reconsideration of the petitioner or their appellants. Prayer for interim relief. The following observations are made by the division bench. following. The following excerpts of the order that was signed the division bench are of relevance. As it was submitted by the learned counsel for the petitioner's appellants before the division bench that there are interim orders passed by the coordinate benches of this court. This court has made a query to the learned counsel appearing for the petitioners about the interim orders passed by the coordinate benches. Full stop. In response, Ms. So-and-so, learned counsel for the petitioners, has submitted that the coordinate bench in the lead petition, WBC number 1793/2026, has passed an interim, has extended interim relief in the following manner. Which paragraph under? The last paragraph is list accordingly.
In Sohar Ali's case, Lacho, WPC 373826.
So only is passed by this court only.
After the order passed by the
After the order. But what you projected before the division bench? That 1793.
Yes, that was what was enclosed to the petition. I have the petition with me. Writ appeal.
It is there. In the petition number 1793/2026. There are 51 number of petitioners who survey have approached this court, agree by rejection of their applications seeking settlement. From the facts recorded, it can be noticed that the said petitioners have approached this court, agree by rejection of their applications seeking settlement on the ground that the petitioners are not in possession of land, as well as on the ground that the lands in question have been allotted to the respondent number 5. Post op. It was canvassed before the court that the those petitioners has filed applications seeking settlement of around 215 bighas of land under their possession, and the applications were filed in the year 2024. First off, however, subsequently, the lands have been allotted to the respondent of 5, and thereafter, the patta has been issued in favor of the respondent of 5. Post of, it was further projected. It was further. Post of. Those petitioners had already been evicted. Post of, it was submitted that there are various parameters laid down in the Assam Land Policy 2019, which stipulated that wastelands of the state can be settled. And therefore, the petitioners, those petitioners who had been residing over the said land for the last 50 years had been dispossessed and their applications for settlement had been rejected. Post of. After recording the above, the coordinate bench had made the following observations. Para 10 and para 11. It is not in dispute that it is an admitted portion that the present petitions were evicted from the scheduled land, schedule A to schedule Q, as admitted in paragraph 22 of the petition. So we'll observe as per WC 3738 2026. Thus, it is clear from it is discernible from the pleadings and the submissions of the learned counsel for the petitions that an eviction process was carried out against the petitioners earlier, and there has been re-entry of the petitioners in the same parcels of land. Post of. In the order dated 31/3/2026 passed by the coordinate bench of this court in WPC number 1793/2026, the court has observed, without commenting on who was in possession of the land, that as the land has already been allotted to the respondent number 5, the state respondents cannot resort to the powers under Rule 18 of the settlement rules. This court also makes the similar observation.
The paragraphs comments which I had received, Your Lordship, in that regarding the rejection of the Vasundhara application that they made, it stated that they were, ma'am, sir, stated that the land has been corrected and the land has been already been handed to APDCL as per government instructions. And then regarding the land policy, they have stated, and the Vasundhara application has been rejected as most of them are found mere organized encroacher and nobody could able to show their possession over the land. Again, in many low-lying places where cultivation is not possible has been applied for agricultural land allotment. The Vasundhara website has got prefixed reason for public due to software limitations. The petitioners' RTPS applications for settlement of government cast land as their claims were thoroughly examined and rejected. The concerned circle officer issued speaking orders against the applications which are enclosed with this paravise
So
comments.
file your reply. File your reply enclosing that speaking order. Enclosing all those speaking orders. Because that there, I've been disposing of those other petitions. Because there is a provision for appeal before the Commissioner Secretary Revenue Department.
Yes.
If they want to prefer an appeal, I can dispose of. Right. Today also I have disposed of. Today or tomorrow? Yesterday. Yesterday also, Mr. U.S. Bora. Similar other petition that you can prefer appeal before the Revenue Secretary. That will decide. It is up to you. So for an interim order, same as 37 so and so, which I passed earlier. MSA. No, you are here. I'll record your name. That you are hard. Yes, Mr. Sharma. Huh? No, list the case. I got the two case. Huh? Okay, list the case. Again on for filing of
I'll file the affidavit.
counter affidavits by the respondents.
Yes, Your Obliged.
Yes, Mr. Goswami. Mr. Sharma will start dictating so that next day we can complete because I have to rise today.
Yes, madam.
I mean, going home after 8 o'clock. Hard. This the present petition has been preferred by the petitioner seeking a direction to the respondent authorities to renew the passport of the petitioner, right?
Yes, madam.
First. As per the facts projected in this writ petition, I have heard Mr. T.R. Sharma, learned counsel for the petitioner, Mr. U.K. Goswami, learned central government counsel for the respondent number 1 and 2, and Miss NEPP. You can represent 3 and 4. Where is Mr. Gogoi? Okay, Mr. K. Gogoi. Call him. At least he should show his face. K. Gogoi, learns public prosecutor for the respondent number 3 and Miss M. Mormon. If he comes, he can represent 4 also. And Miss M. Mormon, learned junior government advocate Assam for the respondent number 4. As per the facts projected in this writ petition, the petitioner is a career consultant. This is a private limited company.
Yes.
Okay. And he cannot be owner then.
No, that's company names like this, OPC Private Limited.
So
OPC, if it is OPC.
basically it is a farm perhaps.
Yeah.
Okay.
One person company.
The director in Messrs. Dumik educational consultancy, within bracket OPC. Oh, nowadays one-person company is possible also.
Yes.
Okay. Private Limited, comma, which has its registered office at Gauhati, Kamrup Metropolitan District, Assam. Full stop. The petitioner has stated that he is involved in the field of providing career guidance to the students in different fields based on their potential, interest and potential. And the company, comma, has comma till date, comma, served the needs of the students by effectively addressing their educational issues. First of para. One Mr. Jagannath Buddha Gohain, who approached the petitioner's company for consultancy services to get admission of his or her,
Should be
his daughter in a medical college at Pune against the paid up stroke sponsored quota. However, due to low rank in the NEET examination, comma, the daughter of Dr. Jadunath Buraguhai could not get admission in the medical college. Full stop. Dissatisfied, alleging dissatisfactory service, Dr. Jagannath Buraguhai lodged a first information report against the petitioner on 18/11/2022.
Well, the FIR was lost by the wife of Dr. Jadunath Pura.
Okay.
And one thing-
Dissatisfied with alleging dissatisfactory service extended by the petitioner's company, the wife of Dr. Jadunath Buraguhai, lodged a first information report before the officer in charge Bhangagar Police Station on 18/11/2022. Post up. The said affair was registered as Bhangagar Police Station case number 342/2022 for the offences under section 420 and section 406 of the Indian Penal Code. Post up. After registration of the affair, comma, the case was investigated into and after completing investigation, the IO, investigating officer, had submitted a charge sheet by charge sheet number 235 on 27/12/2023, finding a prima facie case to proceed for trial. Post para. The cause of action for the petitioner to prefer this petition is relatable to is relatable to his application, relatable to an application he had submitted before the regional passport office, Gauhati, seeking renewal of his passport.
My lord, the petitioner is a lady, my lord.
Huh? Lady?
Petitioner is lady.
Okay, lady is what he could issue, she could issue. Renewal of her passport, being passport number M51-78178, dated full stop. The said passport was issued on 14/1/2015 with a validity period of 10 years. And it was due to expire on 31/1/2025. Full stop. After renewal of the, after expiry of, after validity, after expiry of the validity of the passport, the petitioner applied for renewal with application number para 5 ZU 1075179366525 para 5 on 11/6/2025. Post. The passport authority, it is stated that the passport authority, that is responsible to, right?
Yes.
It is stated that the passport authority, that is the response number 2, on receipt of the application for renewal from the petitioner, posted, fix the date of appointment on 17/10/2025. Full stop. However, prior to the date of appointment, the petitioner was informed by the office of the respondent number 2 on 8/9/2025 that her application for renewal of passport had been placed under objection due to adverse reports submitted by the police. So it was then only the petitioner came to know you came to know about Sarsit then only, or what?
Yes, my lord, then only.
That the police had submitted an adverse report due to pendency of Pongagor Police Station case number 342/2022. First up. In view of the procedure prescribed in the notification number ZSR 570 within bracket E, dated 25/08/1993, and the circular dated number, dated 21/08/2014 of the Ministry of External Affairs, Government of India. The petitioner approached the Court of Learned Chief Judicial Magistrate, Kamrup, Metro Gauhati, Trial Court, by filing an application to allow the petitioner to travel abroad and for a direction to the passport authority to renew the passport. Post op. The application stood forwarded to the Court of Learned Judicial, trial court, to the Court of Learned Judicial Magistrate First Class Kamrup Metro for disposal. Post of the trial court. The said application was registered as petition number 164/2026 and thereafter put up before the trial court on 26/2026. Post op. The application, petition number 164/2026 was taken up by the trial court on 26/2026. Post op. However, on 26/2026, none was present on behalf of the petitioner to move the petition. Post op. The trial court, after perusal of the petitioner, proceeded to observe that the court, being a magistrate court, had no ancillary and incidental power to direct the concerned authorities to renew the passport of the petitioner. Post op. Recording such observation, the trial court, finding no merit in the petition, rejected the same by an order dated 26/2026. Post op. It is in the above backdrop, the prayer, the relief sought for by the writ petitioner in this writ petition in the form of a direction to the respondent authorities to pass necessary order allowing the petitioner to travel abroad in connection with her service and to renew her passport is to be examined. Full stop. Para. In the affidavit in opposition filed by the respondent number 1 and 2, it is averred that on 11/6/2025, the petitioner applied for renewal of her old passport number M5178178, provide file number at the office of the respondent number 2. Post op. it is stated that generally an application is granted pre-police verification basis. But due to an adverse police verification report within bracket PVR on the previous application, para 8 আছে দেই, number ZU লম্বাটা আছে, and submission of an adverse PVR by the police authority, on 6/9/2025 with remarks, quote, during inquiry, it is learned that one criminal case has been registered against her at Bhangagar Police PS, right? Bhangagar PS case number 342, year 2022, search sheet number 235, dated 27/12/2023, unquote. And later, an objection letter under reference number so-and-so was issued to the petitioner on 8/9/2025 due to such adverse PVR. Full stop. So you approach directly or what? 8/9. It is further mentioned that the petitioner did not respond to the objection letter. It is ever that in the application for renewal, the petitioner did not disclose as regards pendency of any court proceeding against her. Whereas for issuance or renewal of a passport to an applicant having criminal proceeding pending before a criminal court in India, the procedure prescribed in the notification number CSR 570 within bracket E, dated 25/8/1993, and section 626 within bracket 2 within bracket small f of the Passport Act 1967 are required to be complied with. It has been clarified that such an applicant is required to produce orders from the concerned court granting permission to depart from India, and to submit an undertaking in writing on a plain paper, in addition to the other documents required for issuance of passport under the Passport Act 1967 and the passport rules framed thereunder. Post of para. I have duly considered the rival submissions of the parties and have gone through the materials brought on record by the parties through their pleadings. Okay, we'll dictate the other part because I have to write. Anything factually wrong?
Okay, ma'am.
Passport renewal. Public prosecutor has been made a party, so I have called for your. What we intend that two things. There is a judicial order of the trial court.
Yes.
Because of the clarificatory order of Supreme Court. Nita Khanna, no? Nita Singh. Nita Singh. Because this court is not empowered to set aside that order. Secondly, we will clarify these two notifications. And Justice Vikramnath judgment, Mahesh Kumar something.
Yes, Mahesh Kumar.
That which is a right, civil right. So that he can have the benefit. He is not a habitual offender. 406, 420. Out of that, one will remain.
Yes.
Though two cannot go together. And this is a case that educational listing. What do you say? Sometimes they want to get admitted in colleges having capitation fees. They fail sometimes. This is basically not a front door entry. Simply. Yes, Mr. Borua. Anything? Kolita, which one?
Item 14.
We heard something. Because looking at you and Mr. Gustami, I thought that.
Different case. That was listed.
Oh, that is Mr. K. Chaudhary was there. That is, this is not the case.
Issue is same, Lordship, but that was listed yesterday in different court.
Item number
14.
চাই পেলাই দি দিব এনেকুৱা consent date আমাৰ available date or done. Item J. Kolita petitioner Mr. B. Gusami and additional advocate general stated by Mr. C.K.S. Borua for the respondents. NHIDC Air Board and standing outside NHIDC for the respondents. Present. When do you want? September?
Lordship.
17 September.
Okay, so for any to learn concept of parties, this is the case on 17.
So what was on it?
That day also,
What's that?
I think Vishwakarma Puja will be divided 17. May not be Lordship.
Then 22nd September.
Lodge.
Okay.
Lodge.
No surprise.
There are a series of interviews.
Lodge.